All right. Let me try to summarize last class and also transition to the next class. We're moving on really to the second half of the class. Basically, the entirety before spring break was just freedom of speech. We had a couple classes in association which don't really fit anywhere, so I kind of put them after speech. But basically, the first half class is just association. And I sense both in the comments we were getting in class on Monday and in the minute poll, a little bit of unease, right? I got the feeling that this class was sort of different, that it didn't feel like the other classes. And I got that. Your feedback came through loud and clear, and I want to maybe shed some light on this. On the Supreme Court, for better or for worse, free speech is an issue that both the court's conservatives and the court's liberals tend to agree upon. About 70 of you signed in. I think there's some sort of buffering issue. Just wait. If it doesn't work, I know. 100 people the same. Stop typing. It's fine. I know. One is enough. Just wait. It'll come up eventually. For whatever reason, the court's conservatives tend to agree on speech. And I think as a society matter, people tend to agree on speech. Even speech for those they disagree with. So I find that the first half of this class goes over pretty smooth, right? Even if we're talking about something like flag burning or cross burning, or about the crush films with the puppies, right? There's still a general understanding that, okay, this is at least a close call, right? And then maybe speech one way, speech the other way. The second half of the class isn't like that at all. Going forward, I think we're going to have almost all 5-4 cases. Not everything, but pretty close to it. The rest of the semester, I think, is divided almost 5-4, just about. Might be a couple older cases that are 9-0, like Sherbert, but everything's almost 5-4, right? We're back like in the land of abortion cases where everything's split in half. And I'll give you the precise fracture point. Society enacts some law, whatever it is, a law involving compensation, a law involving discrimination, a law requiring access to different facilities, and then some group comes and says, "Yeah, that's a nice law, but I want an exception to the law, right? I want a carve out to the law. The law should not apply to me because of X." So in class ignore the noise in the background. So in class on Monday, you had general discrimination laws that say you can't discriminate against women, right? And the court said, well, that's too bad. You have a big organization. You have to admit women to your club, the JCs. And then we had the Boy Scouts v. Dale case. You have a general law saying that, you can't discriminate against gay people. And then the court came the other way saying, well, yes, you can. This group is not required to admit as a scoutmaster, Mr. Dale. And the reason why was not because of religion, but a more generalized concern for the freedom of association. And this dynamic, and just take it from my experience, splits classes in half. Not always, but often, right? Because half the class is like, wait a minute, what the hell is this, right? Discrimination is evil. It's oppressive, as someone might say, right? How is it possible that these groups can get away with it because of some nebulous constitutional right, whether it's association in the Boy Scout case, or perhaps you might say religion in some of the other cases we'll study. And the other half says is, what's the big deal, right? No one's making them be a member of this group. Why can't they decide who they're with, right? Or freedom of religion is really important. Maybe we should be creating exemptions to these rules. And I find that often the most important issues in these cases are often unsaid, right? The court will often sort of talk about these high-minded legal issues, about the history of the free exercise clause and memorial and remonstrance and other things, but the actual weighty issue is sort of not spoken of, right? It's sort of just lingering in the background as an aside, right? It's sort of just lingering in the background as a unsaid things. So a lot of things we're talking about may not be discussed at all, but I do think they're quite significant. Moreover, the tests, the various doctrines we get are going to be mushy. A lot of you asked in the poll about Justice Brennan's 7-factor open-ended balance test, where there actually might be even more than 7 factors. I made a quip, good luck for the exam. I mean that sincerely. If you're an attorney arguing a case and you're trying to figure out the Brennan test, good luck, right? This is not just me being a jerk on an exam. These are not tests that are meant to be applied in any rigorous fashion, right? It's not. It's designed to be a test that can mean anything in any case. That's what it's designed for. So as a practicing attorney, you're going to have to struggle with it if you're a free exercise case or association case. I'm sorry. I can't sugarcoat it and say that the law is neat and clear, because it's not. There's no restatement second of the freedom of association. That doesn't exist. We have Justice Brennan, and then we have the Dale case, which I think arguably is in tension with the Brennan decision. All right. That's by way of background, right? Going here on out, what we're basically saying is, can someone go to court and seek some kind of exemption from a law that's general or specific because of their religion, because of their faith, because of their conscience, whatever you want to call it? And I'm just telling you, these issues are far more divisive. In fact, I think the free exercise cases are probably one of the most divisive we'll have this semester. That's just been my experience. Students tend to get more animated in this issue than they do about abortion even. I think abortion people just are tired of it. They're used to it. This issue seems to fracture. Maybe it'll be different. I don't know. We have 88 people in the room. Maybe it'll all just be, singing Kumbaya and holding hands, but that's not been my experiences. And if you're all singing Kumbaya, I'll put you on mute because I can't handle that much singing. All right. Anyone want to comment in general what I just said? I don't want to be dismissive of your concerns, because I do value them, but I'm just giving you just sort of a warning that the course sort of takes a little bit of a turn, because free speech just seems to have more of a consensus. Hey Blake, I see your hands up, and then Mike.
Hey, afternoon. Yeah, that one. Just to be clear, I mean, you can still test us on the freedom of association. We still have to plow our way through it, even though it's just an awful subject. We're not just going over it to go over it.
Oh, yeah. Look, I'm telling you what the legal standards are. And I'm telling you it's not going to be anything meaningful to apply in an exam, right? And that's something that law students hate to hear, but it's the truth, right? Often the law is fluffy. It's indeterminate, right? It's going to be based on principles that judges bring that aren't necessarily the case.
Okay, so you said again what threw me off. It's like nothing to apply on the exam, the law standards. So what do we apply?
Yes. Blake, I'm not trying to be difficult. Imagine you're a lawyer in 2 years, and you get a free exercise case, and you read the Dale opinion and you read the JC's opinion. You got to write a brief. You got to write something, right? Even though you have a 7-factor test where there might be an 8th and 9th factor, you have to make the best of what you can with it. And I'm really not trying to be difficult. And I know law students hate this answer, but invariably you're going to have to figure out the best way you can answer these questions. I don't know what I would do. If I'm arguing a free exercise case, I think you can make credible arguments on both sides, right? We'll have tests this semester in a similar fashion where it's not clear what the hell the test is, and that's what you have to work with.
I mean, I've always found your previous tests helpful. In the previous 2 classes I've had with you, does this topic come up in some of the previous tests? Helpful to try taking a stab at it that way?
I don't remember. But there are other topics that I'm going to give the same warning for, right? Once you get past the first year of law school, things get a little bit messy, right? And this is a topic where it's messy, and I don't want to sugarcoat it. It's a nebulous area of law. I mean, really, what is an undue burden? I mean, I don't know. Ask John Roberts what an undue burden is. Ask Justice Kennedy what an undue burden is. It's a different thing. These are issues that are very tough. And that 7-factor test in particular just always irks me because I just don't know what to do with it. I gave you a completely unsatisfying answer. I'm sorry, Blake. Yeah, I know you're not happy. I'm sorry. Doing the best I can. Yeah, who else? All right. Then let's move on to, this is kind of awful, but true. Not everything's about the exam. I know for law students, that's all you think about, but at some point you have to realize it's not about the exam. You're learning things here that you'll take with you for decades. You'll forget about me. You'll forget about the exam. You won't remember your exam scores in 10 years. I don't remember my transcript is. I have no idea what it is. I couldn't even think what my grades were. But the lessons you're learning here, the thought process is what's going to stick with you. So grades are important. At this stage in your career, I mean, grades are more or less settled. You're in your fourth semester, give or take. Class ranks aren't changing too much at this point. So think bigger, right, of what you're trying to take away from this class. That's what you'll remember. All right. Let's move on. We're moving to the free exercise of religion, right? The First Amendment has several guarantees. We focused at great length on the freedom of speech. Next, after this topic, we'll do the so-called Establishment Clause. That is, Congress make no law respecting the establishment of religion. Today, we're going to focus on the Free Exercise Clause. Congress should make no law prohibiting the free exercise of religion. What does no law mean? Well, we've learned the free speech context. You can restrict speech in certain cases. So the court has not said that no law. Let me deal with that, the negatives. No law does not mean no law. Some laws are permissible. Congress make no law prohibiting the free exercise of religion. What is religion? What is the exercise of religion? What is the free exercise of religion? These are not obvious points. Is religion whatever is in your head? If I decide to make a religion tomorrow, is that a religion? And if I have this religious belief, does that excuse me or exempt me from other types of laws? I really like the first case in this topic. It's also short. I'm sure you love that part, right? It's pretty short. But the first case in this topic really illustrates with clarity these two different approaches to religion, right? And how religion interacts with the state, these two approaches. All right, someone told me, I think up to the D's. Who's next?
I think it's me.
Okay, who's that? I can't see who's speaking.
Emily Damaris.
Okay, Emily, you go up first. Thank you so much. Emily, do you want to give me the facts, please, in Reynolds?
Yes. George Reynolds was charged with bigamy, and he was a member of the Mormon Church, or the Church of Jesus Christ of Latter-day Saints, and that was part of his religion, to marry multiple wives. And he was challenging that he should get an excuse to.
Well, how did this case arise? What was the posture of this case, Emily?
He had a wife, and then he married a second wife.
Okay, and then what happened to him after that?
He was charged with bigamy under the Section 5352.
So it's a criminal case, right?
Yes.
Let me just ask you a question, Emily, then move on. What gives the federal government the enumerated power to prosecute marriage? Is this commerce? I mean, what basis does the federal government have to prosecute this crime? Because again, 1878, we're well before the New Deal here.
Well, it talks a lot about how this has been a crime. I mean, polygamy has been a crime like since common law.
Sure. The states can do it. I'm asking, what gives Congress this power? Where did this case arise? Emily, where's this case from? Where's it from?
in Utah, the third judicial district.
Was Utah a state at this point?
No, it was not.
What was it?
It was just a territory.
So maybe you want to try my question again? What gave Congress the power to regulate marriage in the territories? It's referenced in the case. They discuss it.
I guess the Commerce Clause, because this was.
It's not the Commerce Clause. Grant?
Because it was a territory similar to the Dred Scott case.
Oh, good analogy. Well, what's the relevance of being a territory? Why is that relevant?
It's not a state and managed by the legislature, by the federal government. Okay,
I think you got it right. The federal government has power over the territories, right? They don't need the Commerce Clause. Right? Thanks for that, Emily. Thank you for that, Grant. Right. I just mentioned that briefly because you're asking why on earth is a federal government regulating marriage? The states have done that forever, right? The short answer is it's a federal territory. It's like the District of Columbia. And under the so-called property clause, which was referenced in Dred Scott, very good memory, Britt, or Grant, I'm sorry. This is a judge named Britt Grant, so I just inverted you in my head. Under the property clause, they can regulate the territories. Okay, that's question number one. All right. The second question is, does the First Amendment even apply in the territories? This, wasn't automatic. Perhaps you can argue that the freedom of religion only applies for citizens in states. And the court says no, that the First Amendment has full effect in the territories. That may come as a surprise because some other territories outside the United States, in the Philippines and elsewhere, were found not to be subject to the Constitution, right? Even Puerto Rico, it's unclear, right? So there's this entire weird line of cases where the Constitution applied to territories sort of in America. The Constitution didn't really apply to these sort of other territories outside the United States. Far beyond the scope of my class here, but I wanted that bug to just put in your head. All right. Okay. So thank you for that, Emily. Chris, are you next? Or I think we have slipped up.
Maybe. I'm going to DEM, I think so.
Okay, there you go. All right. So Chris, you're up next. All right. So let me ask this question, please. The LDS faith, the Mormon faith, basically pretty come close as requiring multiple spouses where circumstances permit. That's no longer their position, but this was a position back in the 1800s. The facts were in a dispute, right? He had multiple wives, right? So we're not challenging the sufficiency of evidence, right? This is a case where he admitted, he's violating it. What was Reynolds' argument about why this prosecution was invalid?
He believed that his faith and his religion under the First Amendment trumped the neutral application of the criminal law, making the enemy.
Just don't use the word trump. Just explain what that means. So he thought
the First Amendment took precedent or was more important over the neutral criminal law that was applied to him.
Okay, I'm just going to tweak what you said a little bit. We said more important. I'll say inconsistent with or conflicts with. Maybe just be precise, right? And Chris, when there's a conflict between a statute and the Constitution, which one prevails?
Constitution.
Right. So it's not that he thought it was more important. It's the Constitution is more important, right? Then the question is there actually a conflict, right? If in fact there is a conflict between the Constitution and the statute, supremacy clause, that's easy, right? The federal Constitution prevails 100% of the time. But the court has to ask, is there in fact this sort of conflict? So the court's opinion here, I think, is actually pretty good. And the reason why I say it's good, not because I agree with it, but it's very clear. And I think it tries to trace some of the history of the free exercise of religion. It discusses the history in Virginia, which we'll get to in a few minutes. I want to do the Madison's Memorial Remonstrance after we finish this case. So we'll come back to that later, but it does discuss it. Discusses Jefferson as well, the Danbury Baptists. We'll come to that later as well. But the court draws an important distinction. Catherine, you here? Catherine
yes,
D?
I'm here.
Okay, thanks, Catherine. Catherine, the court draws this distinction between opinions and actions, religious opinions and the religious actions. I want you to discuss what's this distinction that the court draws here.
Well, I guess so. You're free to believe that Reynolds is free to believe that I guess you know it's a sin to have only one wife, but once he puts it into practice, it becomes different. Like he's not free to I guess act in that way.
Okay, so
but he's free to have the opinion.
So Catherine, you're saying is you can believe in polygamy, but you can't actually do it.
Right, according to the court.
You seem a little skeptical, or a little bit uncertain. I'm sensing some hesitation in your answer.
I guess just because so when they touch on the fact that like you know if you believed in human sacrifice or whatever, that there's a line that has to be drawn.
Okay, you went
for the good of society.
You went to human sacrifice. You went to my 10th example. I usually give a line of examples of what are you comfortable with. Usually I end with human sacrifice. So you went all the way to the end. So let me that's good, Catherine. Let me go to Macy. I think Macy's next. So Macy, let me ask you this question, please. The court draws this line between opinion and action. This is actually a hard line to draw because most, and I'm not asking about your particular faith. I don't want anyone, if you want to volunteer, it's fine, but that's not what I'm asking you. Most religions and most faiths have a very close connection between opinion and action. So, you know, you might believe that the Sabbath begins on Sunday, or maybe you might believe the Sabbath begins on Saturday, or whatever your faith is. And maybe one way that you hold that belief is by not working, right? That's the second case we have. So Macy, can we draw this sharp line between opinion and actions? In other words, if we told people of faith, you can believe whatever you want, you just can't do anything. You can't act your faith. Would that be problematic, Macy?
I think it would be problematic. I don't think that there's a way to make a bright line between belief and action. I think it has to be like circumstantial.
Okay, so now comes a harder follow-up question. I think you gave me a good answer, but here comes a harder follow-up. In matters of faith, who gets to decide on this sort of case-by-case basis which types of actions are okay and which are not okay? You knew that was coming.
I mean, I guess ultimately the court does most of the time, but...
Well, who does first, right? I mean, who decided to bring this case? This is not Reynolds going to the court on his own. Who brought him to court? Who dragged him there? What kind of case was this?
Well, it was a criminal case.
So who made the first decision to not permit the
federal government?
Yeah, it wasn't the courts. It was the executive branch and Congress working in tandem, right? So, Macy, let me ask you one more question. I'll move on to, I think, Michael's next. In a given society, what kind of religious beliefs do you think would be, I'm sorry, I said the wrong word. In society, what kind of religious actions would be permissible and which would not be permissible?
I mean, I think generally society has certain things that we deem acceptable and things that we don't.
Who's we? Who we keep saying this we?
Society in general, like general civilization.
So which kind of religions do you think might get their actions green-lighted that are okay to do?
Ones that are more prevalent within
our majority society. Faiths, huh? Or at the minority, like a Mormon faith.
Yeah, they're not going to be as wildly accepted.
No. In fact, they were murdered. I mean, I don't know how much you guys know about the LDS church history. And LDS is Latter-day Saints, just to give the acronym. They were run out of town in state after state in New York and I think Ohio and Illinois. They were killed and just murdered in large numbers. This history is just not well known. This was a people who, today they're fairly prominent. We have Mormon presidential candidates, right? But they were not in good position back in the 1800s. Garrett, that might be true. Yeah, I don't know, but that might be true. Who did I say next was Michael here?
I'm here.
Okay, Michael. So let me give you an example, right, Michael? A lot of faiths, wine is a very important aspect of their religion, right? Sacramental wine, right? The blood of Christ. In the Jewish faith, we drink wine for various holidays. So in a lot of different holidays and religions, wine's important. What do you think happened during Prohibition, Michael, when alcohol was criminalized?
I actually believe that some churches were allowed to buy wine for religious purposes.
So the state created exemptions for sacramental wine for the communion. Why do you think those exemptions were granted there, Michael? And you're exactly right. So you knew this history. I was trying to stump you, but you knew it. Why do you think that these exemptions were granted?
Because those Christianity, like Macy said earlier, the other more accepted religions get a green light.
Yeah, very good. I mean, there was a significant number of Christians in society that the legislature wouldn't even think of shutting down sacramental wine. That would not work. But then we got the Mormons, right, who have this sort of unusual practice, which in some civilizations it's very common. In Africa and Asia, it was common apparently, right? But in the Americas and Europe, it was not. So I'll ask you the same question I gave Macy there, Michael. With the free exercise of religion, can we have this sort of circumstantial case-by-case basis to decide what is and what is not exempted?
I mean, I think you could, but I say that until the, tough question gets asked, and then I don't know.
To get to human sacrifice, right? That poor Catherine ruined my hypothetical chain of horribles, right? She cut it off at the first step. But maybe she watched my video from last year, I don't know. But I usually end up with human sacrifice. I usually start with, sacramental wine, which, thank you, Michael. I start with like sacramental wine, which is just, very neat. And then I'll say something like, what if you want an exemption from unemployment insurance for the Sabbath? Okay. And then I usually get to, smoking peyote, which is a Native American sacrament. Then I mosey on up to polygamy, which if you have two consenting adults, what's the big deal? And then I drop the mic with a human sacrifice, and then that usually ends it. I was like, whoa. Now let me try another one. Who's next? Charles, Denver, you here? Denver?
Yes.
All right, Denver. So now let me ask you another one, right? Let's say tomorrow I make up a church, the Church of the Marijuanica, right? Where my holy sacrament is marijuana, and therefore I should be able to, dismiss my prosecution for possession of pot in a state, assuming where it's still illegal. I just make up my church tomorrow and say, you know what? Marijuana is a sacred item, and I am going to use it, and I'm going to smoke it whenever I want, and that's my religion. Stop at stake, go away, dismiss my prosecution. Is there business for the government and the court to say, nah, dude, you just made that up. That's not a real religion?
I mean, I think the government would say so. I think the federal government.
Who gets to decide what's in your head? What conscience is permissible?
I mean, I think the federal government would say the federal government, but I don't really know. I mean, I think if you think that helps your practice of your religion, then I think you have a right to do that, given that it doesn't.
So does everyone become a law unto themselves? That whatever vice you have is now your religious faith?
Well, I think there has to be some degree in which the government helps protect people from harm. So
marijuana is a harmless thing. I mean, it depends who you ask, but I mean, you're just smoking in your home or your church or whatever you want to call it.
Well, I mean, even for like minors or something, if minors.
No, minors just only people at the age of 21 are smoking it. They don't let the kids do it. Of course, people always throw in the children abuse. I can just knock that one out of my hypo. These are consent. Look, if three consenting adults want to get married, no one's getting harmed. Now, if there are allegations of harm, maybe you intervene, but you ban at the outset. Yeah. So there are Rastafarians who do believe that marijuana has some sort of sacred value. I I don't fully understand it, but that's a belief.
That's been around for a good amount of time, though, hasn't it?
Yeah, is there like a time frame for religion is more than 10 years old? It's good. You have to have like a statute of limitations on before you can have religion. Look, I'm not joking. The Church of the Flying Spaghetti Monster. I see a couple of you laugh. Yeah, there it is. Yeah. Thanks, Blake. Yeah,
That was the driver's license, wasn't it?
right. One of their. It's a group, and they want to wear a colander, a spaghetti strainer on their head in their DMV photos. And this is their thing. I look, I don't understand it. I don't know. But there have been some courts that have actually said that people should be allowed to go to the DMV. Yeah, but thank you, Virginia. Pastafarianism, and put a spaghetti strainer, a colander on their head. Right? But this is also not a trivial issue. What about if a woman wants to wear a veil in front of her face on a driver's license photo? Oh, how did we saw those? A person in California, she went to the DMV with a mask, with a face mask on. They took her photo with the they put their photo with her face covering. Marcus says they believe their ancestors are smoking with them, the Rastafarians. Okay, who am I to judge that? All right, thanks, Denver. I appreciate it. So look, let me try to bring the case back to bring the case back to the Reynolds case. The court here draws this bright line between belief and action. You can do whatever you want up here, but the state doesn't have to let you do it in real life, IRL, as we say, right? And that really trivializes religion, because so much of religion is doing stuff, right? If it's just holding views in your head, that's not a very effective religion. Every religion, and I'm seeing 87 people in the Zoom room, I'm sure you all have your beliefs, what you believe, what you don't believe. It's not important to me. But your faith, whatever faith you have, suggests you do some things and maybe not do others, right? It's not only action, it's inaction. So we'll do cases later involving pacifism. What if you're opposed to war, you're a Quaker or you're Amish, and you seek an exemption from the draft? Well, that might be an easy case. What if you're a Quaker or Amish and you seek exemptions from payroll taxes? Why? Because your taxes are being used to fund war. Oh, can you get paying taxes for religion? I'll give you one more. What if you're working for some company and they start building munitions for war? You work at a sheet metal factory and you learn that the sheet metal might be used for a tank or an air or a fighter plane. Can you refuse to work at this metal factory because you object to the labor of your hands being made into weapons of war? If you're a Quaker, for example, right? Where does belief end and action begin? And I'm trying to tell you, if you want mushy tests, some of you didn't like Justice Brennan's 7-factor test. This ain't much easier, right? How do you draw that line? And the Reynolds case, I think, draws this really bright line that I think is not easy to draw. But the second half of the Reynolds case, I think, is a little bit more defensible, right? The court seems to say that it shouldn't be the court that creates exemptions, right? If you have some sort of religious practice or religious action that needs protection, go to the legislature, right? Go to the Congress, go to the State House. Don't go to the courts. It's not the job of the judges to create exemptions to laws, to general laws. We'll see this again in the Smith case. Oh God, after spring break, you're way away from it. But there's a case involving a peyote for Native American church. We'll do this after spring break. But the Reynolds case here, I think, is very, I think is very clear. You know what they're saying. It might not be right or wrong, but it's easy to understand. There's a hand up. I see Chris's hand.
Yeah, so then how does this, because I think that the Supreme Court after this then said marriage is a fundamental right. How does this go with marriage being a fundamental right and two people getting to consent about who they want to marry, even if it's a throuple or whatever it might be? Because it seems to me like this doesn't actually go with that fundamental right anymore.
So let me answer your question, Chris. I'm laughing just a little bit. During the gay marriage litigation, the advocates for gay marriage had no answer for polygamy. None. Zero. if you go to the oral argument in a Bergefell, was it Marion Bonato? I can't remember if she did Windsor or Bergefell. I can't remember which one. Oh, no. Or was it Robbie, Roberta? Anyway, I can't remember the lawyer's name. It was one of the lawyers who did those litigation. And someone asked her about polygamy. And look, her answer sucked. She had no answer. She just tried to tiptoe and not say anything. And, it wasn't because she was a bad lawyer. She knew she had no answer, right? Because once you say that marriage is marriage and love is love, why two, not three? Indeed, there's a far longer historical pedigree of polygamy than there was of same-sex marriage, right? Same-sex marriage didn't exist until, was it the Netherlands in the 2000s? Like, not that long ago. Polygamy was from biblical times, right? Every nation on earth had polygamy, and at a certain point. So their intention. I'm sorry,
Yeah.
Chris.
The Muslims could come and say, we've existed for 1,500 years. This is our belief system, and we're not allowed to do this here. The Mormons, that was a pretty new religion, so.
Yeah, so there have been follow-up cases after Bergefell involving polygamy, and the courts just run away from them because they know they can't reconcile them. The Sister Wives, it's this show from what's on TLC, whatever one of these reality show channels, about basically thruples, people who live with multiple spouses. Now, they're not legally married; they're just sort of like together, and the state does not want to prosecute them because they don't want to list this. Because look, it's hard to reconcile. So your question's a good one. Nancy, I see your hands up.
I'm one of the people struggling with the last class of this one. But one of my biggest problems, aside from just what you already pointed out, that this is subjective majority opinion, I also think it's racist because they're only looking at Europe and England and Wales and the US, not considering other cultures. But my biggest problem is that they seem to be drawing distinctions on these very subjective moral lines. It's what the majority, what the founding fathers' morality was. But if it had been, I could see maybe an argument on policy, like issues with dealing with taxes, things that benefits that marriage brings, that it might be more difficult with in a plural relationship. But when you talk about it on terms of morality, that's where that's why I had such a struggle with the Boy Scout case and this, because you're drawing lines on people's sexual lives, which are supposed to be private, and then morality. And
well, keep in mind, this is 1878. This wasn't 1969 when Griswold and Roe were decided. So this notion of privacy you're discussing wasn't a thing in the 1870s. And the state did regulate almost all aspects of married life. Divorce, illegitimacy. If you weren't married, your kids were bastards. They were deprived all inheritance rights. In many states, women who were married had no rights of property in many states. So I get your discomfort, and Nancy, my advice to you is buckle up. It's gonna get worse.
Not discomfort; it's pure anger. But
well,
yes.
Okay. Oh, anger. I'm sorry if I got your adjective wrong. Okay, so buckle up. It gets worse. Look, First Amendment used to not be a required class, so generally only people took it who want to take it. Now it's required, so it's a very different feel for me because it's just different. In addition to being 3 times the size, you have 20 people in First Amendment. I have 90. It's just a different caliber of people who are approaching it. It's different than first year common law. Common law is just issues just feel a little bit different. This one gets people angry, to use your word. But yes, you're exactly correct in your reaction. So I have no, I think you're approaching it just the right way. Okay. All right. So in the end, the court rules in favor of the United States and upholds the polygamy ban. Indeed, Utah was admitted as a state to the Union on the condition that they get rid of polygamy. It's in the Utah Constitution, right? So to go to Chris's question again, were Utah to legalize polygamy, I think they might become they would become a territory again. They have to lose their statehood. It's like I'm being mostly facetious, but this was such an important issue that they had to basically put in their state laws a ban on polygamy to permit statehood. Okay. All right. 10 minutes left. Ugh. All right. The next reading you had was very famous. It was James Madison's Memorial and Remonstrance. Now, what the hell is Memorial and Remonstrance? He's writing about and remembering a very important issue, and that's sort of what it's getting at. In Virginia, there was a proposal by Patrick Henry. Remember, give me liberty, give me death, right? Patrick Henry, who wanted to impose a tax on people. And that tax could be used to pay for churches or other seminaries of learning. So it didn't have to be a church, but some sort of seminary of learning for whatever faith you wanted. The bill was defeated. So that's the history. And in fact, Thomas Jefferson wrote a very famous bill for religious freedom, which we're going to talk about later. But before the bill was defeated, Madison wrote this anonymous pamphlet called the Memorial Remonstrance, where he discussed religion. And he makes a lot of, I think, very significant points that we'll come back to throughout the semester. He describes religion as this sort of inalienable right. And we hold these truths to be self-evident, right? These inalienable rights that you can't force someone to deviate from their conscience, right? We all have our beliefs. And when you impose upon someone a different religious system that they don't agree with, it's quite bad, right? You can't force someone to believe. You might be able to force someone to pay a tax or to take a job, but you can't force belief upon them. And then Madison says, in some cases, making a person pay for something could itself violate that conscience. Now, we all pay taxes, right? We all pay taxes, and there are taxes on things that you may not like. But this was a very specific tax that was directed to houses of worship. I suppose what would happen if the legislature just said, okay, we'll take a general tax and we'll take 5% and put it towards religious uses. Would that be okay? But Madison says that we cannot let this will of the majority, right, always trample on the rights of the minority. This is in the language we're thinking of with the polygamy case. But Madison seems to think in some cases the majority will prevail the minority. And that's something that law students often have difficulty with, right? How can it be that the majority prevails? Well, we have a democracy, and often those with more votes win. And those with more votes may not let those who can't vote vote. You say, well, fundamental rights, what does that even mean? That's something the courts make up, right? Why is it that the unelected judges get to intervene? Law students hate when I say it, but it's true. For many years in American history, the court simply deferred to whatever the majority said. And so that's an awful thing. But that just means that the people were awful, right? It's not that the judges were necessarily that bad. They were merely deferring to what the people wanted. In this case, the majority wanted to ban polygamy in the Reynolds case. In Virginia, they decided not to impose the tax. So sometimes popular will goes one way and sometimes it goes the other way. I know, uncomfortable. So I'm telling you, you won't remember me or anything else, but you'll remember these lessons. They stick with you. It's the strangest thing for what you actually remember from law school. Your day-to-day, you're going around, you're studying, you're writing your papers and stuff, but 10 years from now, you'll be in your business. You'll be lawyers, you'll be doing stuff, but some things I think do stick with you. This is going to be one of them. Come back in a decade, tell me I'm wrong. Maybe I'm wrong. I don't know, but that's just my sense. All right. Any questions on the Memorial Remonstrance? And we'll do the Sherbert case next. Anything on Memorial Remonstrance? Really, we'll come back to this later because every modern case cites Madison. They all cite Madison and Jefferson. Yeah, Gavin, go ahead, sir.
Just on the basis of morals as the foundation for these laws, we had the case in 2013, I think it was Windor, where it was basically moral disapproval can no longer be a foundation for laws.
That's what Justice Kennedy said.
Right. So how do you reconcile?
He's wrong. He made it up.
I guess that's the simple basis, but it's still on the books, right? So how do you reconcile?
No, he's not in the court anymore.
Oh, you're right.
Yeah, no, it's not on the books. No, I mean, look, the biggest revolution of Windor was. Were you in my common law class or property? I can't remember.
I was in common law.
Right. So the biggest revolution of Windor was a statement that moral disapproval is not a rational basis. And really that came from Lawrence even some years earlier. That was revolutionary. Because once you disentangle moral disapproval from law, the basis of a lot falls apart. This is why Scalia was so angry in those cases, right? maybe he didn't like gay people, say whatever you wish, but he was livid about this moral disapproval line because he recognized it. And by the way, where did it come from? Moral disapproval? It was Brennan all along. He said in a case, Moreno versus Department of Agriculture in the 70s. Brennan wrote this one line in the 70s. Moral disapproval is not a rational basis. It was just a throwaway line. And Kennedy picked up that line and ran with it for 20 years. Right? So really, when I says Agatha all along, it was Brennan all along. Right? Just the things he said, these sort of open-ended statements 30 years ago, would just blow up decades later. Right? Just it's remarkable if you trace that progression. If you have the 100 Cases book, just read the chapter on Windsor and Obergefell, and this will fill it in. Thank you for that, Gavin. Yeah, no, but the short answer is Kennedy changed significant amounts of law in a very quick fashion, right? But I don't think that's good law anymore. I don't think there are 5 votes for that position anymore. No, I mean, nothing's being overruled. I don't think Obergefell is being overruled, but I don't think you'd have a 5-justice court saying moral disapproval is not a valid basis to rule. I don't think we get that. All right. The next case, or the second case, is actually pretty straightforward. And it's easy. Again, Justice Brennan, right? It was Brennan all along. Adele Sherbert was a Seventh-day Adventist. This is a religion that celebrates the Sabbath on Saturday versus Sunday. Okay. Why does this matter? Because in South Carolina, there's a law, right, that if you apply for unemployment benefits, the state will be able to try and find you a job. But if you refuse to take the job, then they don't give you the benefits, right? The state would never have forced a person to work on Sunday because that was the Sabbath of the majority of society, right? They wouldn't force you to work on a Sunday. But they thought nothing of forcing Sherbert to work on a Saturday, right? Because that wasn't in their realm of possibilities. Now, could the state have said, you know what, Adele, you're a really nice person. We have your faith. We're going to exempt you, right? They could have, but they didn't, right? They said, Seventh-day Adventist, too bad. We're going to make you work. If you don't, then you don't get your employment benefits. So she went to court and sued. And what Sherbert sought was basically the same thing that the Mormon, Reynolds, sought. He wanted an exemption. He says, okay, I get it. The general rule is Sunday is a day of rest, but Saturday you have to work. But I need an exemption because in my belief, the Seventh-day Adventist faith, the Sabbath is on Saturday. And Brennan ruled for her, and he did a lot of things very quickly, which I think radically altered case. In fact, I think you want to talk about tension. I think Sherbert's in tension with Reynolds. I think they're hard to reconcile. Reynolds will say, well, yeah, sure, you can believe the Sabbath is on Saturday, but what you're asking for is an action, deciding not to work on it, right? Right? You're asking something more than belief. So really, the Sherbert case, I think, broke down the line between action and opinion, right? It's not just what's in your head, it's what you do outside your head. Right? No one's forcing her to work, but she just would be denied benefits. Right? She wanted some benefit. All right. So there are 3 parts of this opinion. I might go a little bit over. If I do, I'm sorry. You can watch the video later. The first part of the opinion asks about a burden. Right? Does this denial of benefits impose a burden on a free exercise? And here the answer is, of course it does. Right? Of course it does, right? It's burdening her because she can't accept the money. She can't accept the job on Saturday. Why is that the test, right? Again, if the line is between action and opinion, who cares? No one's forcing her to change her beliefs. So this is just a new test that was made up, right? It became known later as a substantial burden test. Again, not the undue burden test. Lord help you. It's different than Casey. This is called substantial burden. What's the difference between substantial burden, undue burden? I don't know, right? The court doesn't really explain, but these are just different words. So this first prong became known later as a substantial burden test. It's another test for you to remember. There's so many tests in this class. The second element of Brennan's framework asks, what is the state's interest, right? Why is the state denying benefits to Sherbert? Here the court says the interest must be compelling. Right? It must be a compelling interest. This is the language you remember from strict scrutiny, right? It has to be of a compelling interest. This means the state interest of the highest order. Here, South Carolina said, well, we're worried about fraud, right? People who just don't want to work on Saturdays will pretend to be Seventh-day Adventists. Okay, that might be true, but if you're worried about fraud, take it on a case-by-case basis. Investigate someone. If they're engaging in fraud, you deny the benefits. You should not have a blanket policy. In other words, the state's interest here is not compelling. The third one is called the least restrictive means test. The least restrictive means test. And this one's a little tricky to explain, right? Let's say the government really does believe that they're afraid of fraud, right? They're afraid that people will apply for this Saturday exemption because they just don't want to work on Saturdays and they're just making stuff up. Are there other ways the government can eliminate this fraud? Yeah, they can investigate. They could have, maybe request a letter from your preacher, right? There might be other ways they could verify that the claim here is legitimate. This goes to narrow tailoring, right? That the policy of the government must be super duper narrowly tailored. But it's not just narrowly tailoring. This is called perfect tailoring, right? You have to have the least restrictive means, that there's no other way that you can accomplish this goal, right? The only way you can eliminate fraud is by banning it outright, then that's what you have to do. But this is almost never going to be satisfied. This least restrictive means test is basically fatal, right? You often say strict scrutiny is fatal. This is fatal. Once you go to the strict scrutiny standard of least restrictive means, the government can't win. Because there's always some judge, Brennan, who will find, oh, but you could have done this, this, or this. Why didn't you do something else, right? And once you find other alternate options, you lose. So really, we went from the Reynolds case, which was uber rational basis, just really deferential, right? Uber deferential. To Brennan, it's like super duper strict scrutiny, right? This was a radical change in free exercise policy. And I think what we're going to see is the court was not happy with Brennan's test as it got more conservative. And the next case we have after spring break, the Smith decision, Scalia knocks out the Brennan test. He knocks it out, said this is not good. All right. Questions on this? And if you need to go, that's fine. You can just watch the video later. Denver, go ahead.
I was just able to check in. So if we checked in later, are we still going to be good for class?
Can everyone just try checking out? I think everyone but about 5 or 6 people. If you can't, just email me. That's fine. But I think 88 people have checked in. So if you can't, that's fine. All right. I'll have the minute poll on if you can do it. If not, don't worry about it. I'm not sure what's going on with iClicker. It's usually pretty reliable.
I also had a question, but I don't want to keep you going.
All right. Anyone else? All right. You guys can go. Denver, you can ask your question if you want. That's fine.
So I kind of skimmed the peyote case after this. And I know with Texas, at least you have to have 25% Native American blood, I think, right, to be able to participate in peyote use.
I don't know. If you say so.
What I've read, that's the law, because I just thought it was interesting. But so how do you? What it kind of seemed like to me in that next case is that's kind of a cop out of the question that you had kind of asked, that sometimes it's permissible, sometimes it's not. So they're essentially allowing themselves some latitude to make that decision.
I'm not familiar with that rule. I'm not sure, but under Texas is actually, short answer is Texas has a law called the Religious Freedom Restoration Act, which creates even more protection for religion. So it's not under the Smith standard, but let's come back to it when we do Smith, okay?
Okay.
Yeah. All right. Go ahead. Who's next? Reed, go ahead.
Oh, I was just wondering, this is more of background. Why is it this case got taken up to the Supreme Court? Where do you have, so I watched a video, it's kind of an expose on Hasidic communities in New York. I heard a story about they used to decorate their tents for Sukkot with pink slips from being fired on Saturdays for keeping the Sabbath. I'm just wondering, is there a line of cases out of the Southern District and the Second Circuit relating to any like Jewish communities, any Sabbath day, like their Sabbath practices?
Oh God, yeah. Tell me about it. A lot of them. Yeah.
Yeah, I'm sure.
Many. I'm involved with some of those cases. There are a lot. Yeah. Who else? Christina, was your hand up?
It was, but I was just responding to Denver's comment on the 25%. My dad has taken part in the Native American church and was a member, and he was able to have that exemption, but I'm not like automatically able to, despite my Native American blood.
Oh, well, can I call on you when we do this next week after spring break? Talk about the peyote?
I think I'll be up around that.
Oh, I mean, I may call on you anyway.
Yeah.
I actually had a student 4 or 5 years ago who was a member of the church, and he had done the ritual before, which was fascinating. He told us about it. He said it was very bitter. It was very unpleasant. And he said it was not something you do to get high. You know, it's not like recreational drugs, right? This is a very serious ritual they do. And he should explain just how it goes by. Yeah.
My dad was telling me more about it this morning because I read that case, and he was saying how structured it is and how much direction is needed when actually taking place.
Yeah, this is not a bunch of guys sitting around smoking dope. This is not what that is at all. Okay, excellent. All right, anyone else? The few, the proud, sticking around. All right, I'll go off. Yeah, go ahead.
Since we're here and choosing, so that was my.
You know what? Let's just. If you want office hours, I'll be here. I don't want to keep everyone indefinitely, so I'll be office hours by 20 minutes. Okay.
All right. Okay.
Bye, everybody.
All right. See you then. Bye.